everyone, and welcome to the next in the series of the Global Legal Blockchain Consortium webinars. Today we have Glynna Christian from Orrick, who is going to be talking with us about smart contracts. Glynna?
Thanks, Kim, and thanks everyone for listening in today. Looking forward to talking about smart contracts. There is quite a bit of noise around smart contracts, but I think a lot of confusion. So just quickly want to try to cover what smart contracts are, a little bit about distributed ledger technology and blockchain because they're so related, and then really talking a little bit about how smart contracts and DLT are related, and then finally some of the considerations to think about around some different legal issues and practical applications because of the way smart contracts and distributed ledger technology work together. And I may use blockchain or DLT sort of interchangeably as a shorthand rather than trying to distinguish between them, but for purposes of this conversation anyway. But let's get started talking about what smart contracts are. There's really just a lot of confusion, and I even see legal articles not be as clear really as they should be around what smart contracts are. And I think that's been driving a lot of confusion, misunderstanding, and we're even seeing state legislatures take action now to adopt legislation around smart contracts when it might not even really be necessary if there was really more clarity around what a smart contract is and is not. So what is it? The Smart Contract Alliance, which is an initiative of the Digital Chamber of Commerce, uses this definition. I think it's actually a pretty great definition. You can shorthand it a little bit, but it's essentially computer code that with certain conditions that are specified in the code will automatically carry out certain functions. It's really very if-then statements that are written into code. This definition also mentions distributed ledger, and that's because they are so tied nowadays. But smart contracts even exist separate from distributed ledger technology. They're really not new. One of the probably most common example of a smart contract are vending machines. So the code in a vending machine that says, wait a minute, I just got a dollar bill and somebody pushed E3, that means I need to go get a bottle of water and drop that down. That's all done through software. That's if-then code. That's really a smart contract. Another example is automated bill payments or calculations of interest. So those have been around for a long time. Those are not really anything new. And we haven't been doing webinars and CLEs on legal issues arising out of vending machine software. So kind of why are we talking about it now? And it gets back to the point really I raised earlier that smart contracts are really able to scale now and be used in a lot of different ways thanks to blockchain and distributed ledger technology. So let's talk about it a little bit more. I think one of the biggest sources of confusion is the thought of whether smart contracts are a contract or not. And contract law hasn't changed just because there's this new concept of a smart contract. So in order to have a legally enforceable contract, you still have to meet all of the legal requirements to have a legally enforceable contract. There has to be an offer, acceptance, and consideration. And then of course, in connection with all of that, there has to be intent. There has to be capacity to contract on the part of both sides, and there has to be certainty as to the terms. And if you really think about code and how it functions, you can see that depending on its usage, some or all of these may not be met, particularly very automated processes that are repeated over and over again. At a certain point, there may not be intent to continue contracting. Can the machine actually have the capacity to contract? So when you start to really think about all the hurdles that you have to jump through to see whether a smart contract is truly a legal enforceable contract, it may likely not be. That doesn't mean they still don't exist or that you still shouldn't use them. And there are different ways to think about smart contracts and whether they're a contract or not, and how you deal with it. And I think the Smart Contract Alliance has a couple of really good examples of how they explain different types of smart contracts. And when you think about it, code, if-then statements really gives you a lot of certainty that sometimes in a natural language contract that you may not have. Code is not ambiguous. It is black and white. It is if and then statements. Of course, what it also means is that for a lot of complex transactions, and even transactions that are not even necessarily that complex, you really can't code the entire requirements for the contract. So for example, there's no way you're going to put commercially reasonable and those sorts of qualifiers into an if-then statement. Determining the scope of indemnification, determining whether or not a force majeure event has occurred and what the remedies are. Those are things that are just really probably not capable of coding. That doesn't mean that all parts of the contract aren't capable of coding, though, or that certain pieces of it can't be capable of coding. And you can use those pieces in conjunction with a natural language contract. So you can think about it in these couple of ways that the SCA has laid out. One is the code or the smart contract is really external to the natural contract. It automated some terms. Maybe it's what calculates the interest rate on a loan or a credit card, but it's not really part of the contract. That's just entirely external. There's not even a question whether it's a legally enforceable contract or not. Then the other way to think about it is really that the code is internal to a natural language contract, or it is the entire contract itself. So in the top right-hand column of this chart, you can see, in this case, the code is the entire agreement. I think the number of situations where that may be the case are probably a lot more limited for all the reasons I just mentioned. You'd have to have it really very simple contract where it could be tied and written into code into if-then statements. More likely, though, the smart contract code is going to be an integral part of the contract. So it'll either be actually written into the contract itself or maybe incorporated by reference. And so when you start to think about having code as part of a contract, a natural language contract, then you can start thinking about what's the implications of that to the contract, and how do I make sure that I've incorporated the code so it's enforceable along with the rest of the contract. Now, what I haven't talked about yet or haven't mentioned is that, in addition to determining whether or not code is a legally enforceable contract and looking to traditional concept of contract law, you still have all of the other legal frameworks that are out there. So for example, the restatement second of contracts, getting to whether a contract is enforceable or not, whether certain terms have been incorporated in contracts, are all things that you will see in the restatement second of contracts. Uniform Commercial Code, of course, applies to commercial contracts. E-sign, UITA, GDPR, just to give an example of a contract, a law that is not specific to contracts, but is still applicable whether or not a piece of a contract or how it functions is written into code or not. I think there are some commentators who really think that a lot of the legislation that we're starting to see recognizing the validity of smart contract code is really not necessary. Take the view that the smart contracts are already valid under e-sign law and UITA as an electronic transaction or a digital signature. Under those statutes, they generally give legal efficacy to electronic signatures, records, and contracts, as long as there's appropriate written notice and consent to conducting business electronically. Generally, these sorts of statutes ensure that if a law requires a signature, then an electronic signature, which should even include cryptographic signatures, would satisfy the law, satisfy the legal requirement. If the legal requirement requires, a record to be in writing, then that electronic record would satisfy that requirement. If a contract or a signature or a record shouldn't be denied legal effect or enforceability solely because it's in electronic form. And then a contract shouldn't be denied legal effect solely because it's an electronic record. So we already have those sorts of statutes in place. Maybe you can quibble around whether or not this is digital and those only apply to electronic records, and whether there's some, way to differentiate those so that they wouldn't be covered. I think maybe a little bit of a, quibbling around the edges there. I think the general intent of those existing legal frameworks are things like smart contract codes and electronic signatures would still be in effect. But in the meantime, states are looking to look like they are being very proactive, encouraging technology, and passing additional legislation. It has the unfortunate effect, or may have the unfortunate effect of causing confusion or inconsistencies with these existing legal frameworks. So you want to always check to see whether any of these existing legal requirements apply, and if not, then see whether any of the new legislation would apply as well. Let's talk quickly just about blockchain and distributed ledger technology, just so we can have a little bit of context for issues around using smart contracts in connection with blockchain or DLT. And anybody who's heard me talk about this before or listened to the prior webinar will know that I really describe it at a pretty high level as, software servers in a database. And clearly blockchain and DLT is more than that. But at the end of the day, it is still really software that has a shared database architecture with multiple copies of the architecture and the transactions in the data. And that's generally the same definition that the Smart Contract Alliance uses as well. Of course, there are some key features of blockchain or distributed ledger technology which makes it particularly attractive, and particularly in the smart contract sense. And I think that's one of the reasons why sort of smart contracts have been able to scale, is when you really look at some of the features of distributed ledger technology. So the decentralization, the fact that it's immutable, and that it can either be a public, private, or even a hybrid network. So let's talk a little bit about what those mean. So first, decentralized, I think that's, these are all hallmarks clearly of blockchain. But one of the ones I think that people maybe focus on the most is that there's really no central location where all of the information is stored. It's not like using Amazon Web Services and all of your data is stored at one of their locations. It's stored across anybody participating in that particular ledger or blockchain. The beauty of that, it means if any one computer on that chain goes down, then the entire chain does not. So it gives the additional redundancies. That's a little bit of the hallmark really of blockchain. It also encourages transparency, which is another hallmark really of blockchain, and everybody having access to that information. Another sort of key feature really that you hear everybody talk about with blockchain is that it's an immutable record. And I cringe a little bit when I hear people say this, just like I cringe a little bit when I hear people use smart contracts in a way that may not be clear that it's not really, or most likely not a legally enforceable contract. A blockchain or distributed ledger network might be immutable, where the information that is recorded in it is not alterable, but there's also a chance where it can be. So it really depends on the particular rules for that blockchain. And it's important, and I'll talk a little bit more about this, to really understand what those rules are. And there have been situations when information in a blockchain has been altered. If you have enough of the participants in the blockchain make the decision to correct it, rewrite it, then that's possible. And if you start to think about, well, if I want to put smart contract code onto a blockchain and store that information sort of indefinitely, and I don't want to use indefinite in a legal sense because this technology is not going to be in perpetuity, but when you think about contract provisions and incorporating this into natural language contracts, then you have to start thinking about what does that mean in terms of return of data, termination of the contract, those sorts of things. So I want you to start thinking about a natural language contract and how having parts of the contract stored on a blockchain might need to be changed. So while you'll hear blockchain referred to frequently as being immutable, just keep in the back of your mind that may not always be true, and it's really very important to understand how the particular blockchain you're working with works and what the rules are around making changes to the data that is stored on it. Now, the beauty of it being immutable, and why a lot of people want to use it, is because it does help with digital identity verification and authorization, and that's absolutely one of the best reasons for using blockchain and why you see smart contracts being used in connection with it as well. So that's certainly a very good thing, and it's helping driving use of this. But there are situations in which it can change, and that's important from using it in connection with a natural language contract. To just dig deeper, a little bit deeper on that, I want to talk a little bit about the differences between public or permissionless blockchains and private or even hybrid blockchains, because this gets to that same point. So of course, a public blockchain is completely open. Anyone can join and participate. They can either read, send transactions, and all of that is transparent. They can also participate in determining what records get added, as opposed to a private blockchain where maybe only certain participants have the ability to make those sorts of decisions. There's very little or almost no privacy for these transactions. It can be difficult to scale, but on the flip side, it's also completely decentralized. There's no one overall authority running how this works. Lots of very good things about public blockchains from particularly from a technical standpoint. From a legal standpoint though, particularly using them with natural language complex contracts gets to be more challenging. So I think particularly when you think about enterprise blockchains, what you're really, which I think you'll see more of in corporate business use cases, you're most likely really talking about private or permissioned blockchains or hybrid blockchains. Each one of those will have their own rules for how you can use that blockchain. So again, it's very important to understand what those are. They are sort of closed ecosystems. There are different rules for who can participate, what they can do. There are different access rules, and they may even allow for information stored on that particular blockchain to be changed, to correct errors, make updates, make amendments. And when you see a lot of consortiums, and those are growing on a regular basis, many of them follow this model. The software used to operate these blockchains may be open source or a combination of open source and licensed software. That's also sort of important to understand in terms of how you're using that particular blockchain. So that's a little bit at a high level about smart contracts. It is code, it is if-then statements, and may be completely external to a natural language contract and have nothing to do with it. Or it could be possibly an entire contract itself if it meets all of the legal requirements to have a legally enforceable contract. Or it could be incorporated into an otherwise complex natural language contract. And thinking about the enforceability of that, you've got to think through all of the existing legislation, A lot of this is going to be helpful, like e-sign and WIDA, and then some of the new legislation as well. But it doesn't mean that there isn't other laws that you need to think about as well and make sure you're still complying with. So let's talk about some of the benefits and the risk that using smart contracts on blockchains now sort of presents. So of course, it creates some efficiencies. It makes it easier to repeat certain functions and incorporate them into contracts. It allows for authentication, the one true version, for these particular functions that are self-executing through the code. It'll reduce the possibility of a breach. So for example, if you are using code to make a decision around when a payment is to be made, and you're able to code an if-then statement around if the shipment is received by X date at X time, then pay X amount of dollars, it's going to reduce the possibility of breach for the non-payment. Different issue if the shipment isn't received, but at least in terms of whether or not a payment has been made or not, should go away. Also the need then for late fees and termination rights around that. But the risks are things like if you have a contract that is stored on a blockchain, how do you go back and amend it? That gets to the question of, is it a public blockchain or is it a private blockchain? And can you make changes to what you have stored on that blockchain? If it is an automated contract, how do you go back and make sure it terminates when the rest of the natural language contract ends? You've got to make sure that you're still complying with data privacy and cyber requirements. So from a GDPR standpoint, which has been a lot of the talk around data privacy lately, and now California's new consumer protection legislation going into effect next year, how do you make sure that you're still complying with all of those requirements if you're putting data on either a public or a private blockchain? When you really think about it, despite all of the benefits of a blockchain, it may be antithetical really to the concepts of privacy, data privacy, and keeping information confidential, and the ability under GDPR, for example, to remove information and to be anonymous. How do you make sure you can do all of those sorts of things? There may be a hacking risk because of the coding error. So the more code you create and have as part of the performance, your risk then is not necessarily as much around the non-performance like you might have in just the normal natural language contract, but what if there is a hack? And what does that mean? Who's responsible? Is it a breach? Is it not a breach? And how do you really allocate that risk? And then of course, as I already mentioned, there's so much objectivity that's required in a smart contract because of the if-then nature of it. It's really difficult to do really complex contracting. When you think about the different types of smart contracts, external, not part of the contract, internal, where it's the entire contract itself, but it has to be super, super simple. And then the other bucket, which is really where it's a part of a complex natural language contract, I think that's probably the hybrid approach that you will see most likely. There are probably a few situations where you wouldn't want to try that, and you just flat out shouldn't do it in some situations. So for example, in a consumer transaction, if you're looking at finding ways to incorporate the code into the contract in order to have that hybrid, you're not going to want a consumer to have to read code. Your consumer agreements need to be as simple and straightforward and understandable as possible to make sure they're really enforceable. So I wouldn't book code into your consumer contract. There are other types of agreements with really specific requirements around how they have to be executed or recorded that just don't necessarily work for smart contracts, wills, for example. It's important if you're going to think about using a hybrid approach that you really understand the information that's being passed, what's going to be the triggering and what's the result. Because depending on how all of that's going to work, you may need to make adjustments in your natural language contract for that. How do you make sure that the information that is being passed into the code is accurate? What if it's not? Are you really clear about what the triggering events are? Are there some triggering events that haven't been thought about or aren't captured? If so, what happens then? And then what's the result on the execution of that code? And as I mentioned, how do you stop the code from automatically being self-executing if the agreement terminates? So lots of things to think even around incorporating the code there. When you start to think about sort of a checklist or other things to really think about as you're working on a natural language contract, I want to give you some ideas to be thinking about. And there's no, I think, necessarily right answers on any of this yet. And I think there are probably lots of things within existing contracts to think about still. But these are at least some of the ones that we've been thinking about and trying to address when we're looking at contracts that may have a smart code component. We've really already talked about sort of the first bullet point here. It's unlikely really that the smart contract code is going to be the entire contract, but if it does, you've still got to comply with all the existing laws. You've got to comply with OFAC. You have to know who the party is you're contracting with. You need to know the jurisdiction where they're located in order to have appropriate taxes if relevant. As I mentioned, you still have to comply with GDPR and all the data privacy. So there are still legal hurdles that you need to jump through, even if the code itself is going to be the entire contract and it's a very simple contract. Now, if you're looking at using smart contract on more of an enterprise level, maybe you're going to use a blockchain or other distributed ledger technology as an alternative or an additional network, just like cloud services. It's probably time to go back and start thinking about your existing template agreements for which you provide those services if you're with a service provider, or if you're a customer, rethinking some of these provisions too to make sure that you're adequately covered around some of the potential risk. So for example, if you've got a stock purchase agreement and you're looking to acquire the assets or stock of an entity, there's usually a definition of what a contract is from a due diligence and a rep and warranty standpoint. And you may want to make sure in those cases that contracts include both electronic and digital contracts to sweep in any smart contracts that may be enforceable in and of themselves. It's important, as I mentioned already a few times, to really understand the rules around the particular blockchain that you're working with and how that could affect your contract. So if there are unilateral changes or updates to those rules, or if the blockchain will perform in a certain way, that may have an impact on your commitments in the contract. And you might need to have that flexibility, the ability to flex with those rules captured by your contract as well. So you may want to even specifically mention those rules within your natural language contract. Along those lines, you frequently see in contracts some language that says there's no third-party beneficiaries of the agreement. And you might want to make it really clear that other participants in the blockchain are also not third-party beneficiaries. Or you might want to make sure that they're third-party beneficiaries. So if there is some form of a breach, maybe there's a hack into some of the code, that you at least have some type of ability to either litigate or have some kind of recourse against other participants in the blockchain who maybe caused the issue. So really trying to think through contractual privity with other participants in the blockchain are going to be really important in terms of the contract you're signing for services that either use blockchain or by which you're providing blockchain. The effective termination, I think, is a little bit of an interesting one. You know, most contracts have a really simple statement that says, you know, if the contract terminates or it otherwise expires, all the licenses go away, nobody has responsibility to do anything else, we're going to return each other's confidential information. that really needs some additional thought to the extent that you're using smart contracts on a blockchain or distributed ledger. You might want to have a specific requirement to return keys to make sure that somebody else isn't able to access the information that you've stored on that particular blockchain, because you're unlikely to get it back. That's the whole point of using a blockchain. And the way maybe to do that is through restriction of the assignment of the keys, or making sure the keys come back to you on termination. Sort of generally in terms of assignability provisions of contracts, you might want to have some calls out around keys, where the keys to access the information can't be transferred to anybody else that you're not aware of during the term. You might even want to have those keys held in escrow during the term of the contract as well. So lots of different things to think about around the fact that data and information and code may be stored on a blockchain. And depending on how that particular blockchain works, it may be immutable and may be stored indefinitely as long as that blockchain is still being operated. And what does that mean on termination of your contract or your provision of services or receipt of those services? So that's part of the contract that started to get a little more review after GDPR and how you're going to return data. But it's particularly if there is a blockchain component, you really want to think about that in terms of your natural language contract and changes that you might need to make. You may also need to take a look at things like your service level agreements and warranties. So for example, if you're a service provider and you're otherwise providing a 99.9% availability guarantee for your services, if you start providing a portion of those services using a blockchain network, for example, then you might want to carve that out. What we're seeing around service levels now, where a service is based on blockchain, is that the service level only captures really the APIs and the things that are proprietary to the service provider, and doesn't cover the underlying infrastructure of the network itself, the blockchain itself. So if for some reason there were any issues with it, that would not be a breach of the service level agreement. And that may be completely fair, but something to make sure that you're thinking about and really understanding around either how you're providing your service using a blockchain component and the service level commitments that you're making, and whether you want to include the entire service, including how the infrastructure functions, or you want to carve out things like blockchain infrastructure. And if you're a customer using a service that includes a blockchain component, that's also something to make sure that you understand. I also mentioned in here exceptions from confidential information. So it's a very common term in confidentiality provisions that information that is publicly available is not considered to be confidential information. Pretty standard stuff. But even things like those provisions in natural language contracts need to be rethought and maybe revised, particularly if you're using a public blockchain. If you're putting information on it and it's a public blockchain, then sort of the way the normal confidentiality provision would work is it's no longer confidential information. That may be okay, because frankly, if you don't want the public to know about it, you probably shouldn't be putting it on a public blockchain in the first place. But you need to be thinking about those sorts of things and the way these sort of legacy contract terms work, and whether they need a refresh when you're using smart contracts on distributed ledger. If you're going to include the code, you may want to include it as an exhibit to the contract, or at least incorporate it by reference, maybe have a link to it to allow you to make changes to it. And you'll want to make sure that when you are looking at the incorporation and order of priority provisions of the contract, that you cover any smart contract code that should be incorporated by reference. You might even want to address it in terms of an order of precedence. So if the code and its function should control over other terms of the contract, or anything else outside of the contract, say a purchase order, for example, then you want to make that clear in your order of precedence too. Just to be clear, in these contracts, you also might want to address that electronic signatures are permitted, and make sure it includes both electronic, digital, cryptographic signatures. If there is an error in coding, as I mentioned earlier, you just want to make sure that from a limitation of liability standpoint, an indemnification standpoint, and a warranty standpoint, you've thought through that and how risk should be allocated around that, thinking about what your recourse would be and who that should be against. Is it really with the other party you're contracting with, or is it a risk that arises because of outside third parties? And if so, is there a true remedy there, and how would you allocate that? We talked a little bit about how do you amend the code, particularly if it's in an immutable blockchain. There may be other ways of doing that. So for example, some predictive programming, using a blockchain that allows you to go back and change the code, different things to think about. So if there are issues with the way the code has been coded even, how can you go back and fix that? That's something that you probably want to dictate through the terms of your natural language contract. So it's very clear what the process is and what the requirements are to make sure that a change is possible and also enforceable. And then of course, also thinking about really what are the governance and dispute process when you've got any amount of object code or smart contract in your contract. How do you make sure you have all of the relevant players involved? If you typically use arbitration, how do you make sure they're included in the arbitration? They may be indispensable third parties. Is there some form of dispute resolution process that the blockchain uses that you could participate in as well? If so, what's the impact, or is there any impact on the natural language contract? Would you want that to be binding or not? Do you want to be able to seek other remedies outside of that? So depending on the service, the blockchain you're using, and sort of the information at risk, there may be different ways you want to handle and think about what the governance and dispute resolution process is there. So that's really smart contracts and distributed ledger at a high level. I hope that's helpful, at least to clear up some of the confusion around really what smart contracts are, because I still get lots of questions from people thinking that a smart contract means an actual contract without understanding that it's really probably just software and never rises to the level of a legally enforceable contract. But even if you start to understand that, when you think about it in then the rest of the contract, in the context of having a legally enforceable contract that may rely on smart contracts, and how that and blockchain may affect provisions that have been in contracts for the 25 years I've been doing this at least, and how do you want to rethink those in light of the new technology is really sort of interesting and fun to think about. I don't see any questions, but I'm always happy to answer. Feel free to call me, email me anytime. I'm always happy to chat about it, and thank you very much for your time.
Thank you so much, Glynna, and I'd like to thank everybody who joined the webinar with us. If you didn't get a chance to see the previous webinar that Glynna offered, it is available on the legalconsortium.org website.